Welcome to this webinar entitled Acquiring Land by Adverse Possession, a Conveyancer's Guide. So my name is Lorraine Richardson and as you may or may not know, I am a property solicitor and a legal trainer. I've been doing both for a long time. I'm now freelance, but I've been in practice for a long time. I still locum, but in addition to locuming, I do lots of other things, including I've written a couple of books, the details of which are on your slides, and I also do webinars for lovely people like MBL. If you want to contact me directly, you can either go via MBL or via my website at www.adaptlaw.co.uk. But you don't want to know about me, you want to know what I'm telling you about. So I'm looking at this very much from the perspective of the residential conveyancer. And I'm actually assuming in many cases that you will not be making an application for adverse possession. And I will obviously be thinking about what that means. But what I do think is really important for us as residential conveyancers is that you can recognise and understand whether an application for adverse possession is appropriate. As we often see, a seller will occupy land to which they do not have title. And really my starting point is, well, should an application for adverse possession be considered, or actually is a statutory declaration or statement of truth plus indemnity insurance enough? The Supreme Court has recently considered a case regarding the time limits for making an adverse possession claim. So it is an important topic for us. So I'm going to provide an update on the key concepts and issues, obviously not an entire run through of every step you need to take, but really what you need to be looking out for and recognising. And what I'm particularly going to cover, therefore, is the adverse possession regime for registered land specifically. I will mention unregistered in passing, but most of the land in England and Wales is now registered, so that's what we will be looking at. I'm going to be thinking briefly, therefore, about the statutory framework. The Supreme Court did have something to say earlier this year in Brown and Ridley. I will include a brief note on what your seller client's statement or statutory declaration should cover, and we will think about indemnity insurance. And I will mention unregistered land and the lenders in passing. So what's the statutory framework? Well, somebody who is in adverse possession of land is often called a squatter. And the majority of disputes about squatters, so somebody who is occupying land that they shouldn't be occupying, those disputes are going to be determined by principles relating to registered land contained in the Land Registration Act. Unregistered land is still governed by the Limitation Act 1980.